case briefs, and so much more. LSData's got what you're looking for.
In a 1962 case, heard by the Oregon Supreme Court, a Yugoslavian man named Klimek alleged that a builder, Perisich, failed to fully execute the remodel of an aging residence into a rooming house. Klimek had initially taken the dispute to a lower court, claiming a breach of contract, and had actually won the case. However, the saga was not to end there. The verdict was set aside and judgment was ultimately entered for the defendant. The crux of the issue which led to this protracted legal battle was the simple yet profound question: did a contract actually exist between Klimek and Perisich? While the Oregon Supreme Court clarified that a contract could be born out of either written or verbal agreements, the waters in this case were muddied. Despite the plaintiff's assertions, no formal written or verbal contract formed the base of the disputed work. Klimek, who had bought the property with an intention to convert it into a rooming house, laid claim to an agreement with Perisich, who had estimated the renovation costs to range between $8,000 to $10,000. However, these estimates failed to constitute a formal contract offer, and no concrete details concerning the work's extent, the materials to be used, or the project's specific requirements were established. Ultimately, the lack of transparent agreement, coupled with the plaintiff's failure to present convincing evidence, led the court to decide that no contract had, in fact, been made. The court ruled that for a contract to exist, not only must the offer and acceptance be clear and certain, but there must also be an undeniable meeting of the minds regarding respective obligations. Without having met these essential criteria, the lawsuit fell through, and the lower court's favoring verdict for Perisich remained intact.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.